Welcome to DRTSPR show. This is Dr. Tangella Shivaprasad Reddy alias Dr. TSPR. Namaste, Adab, hello, Swami Sharanam, and a warm welcome to an important show with wonderful guests being busy in interpreting the Supreme Court Constitutional Bench judgment upholding abrogation of Article 370. Abrogation of Article 370, Jammu and Kashmir and Ladakh issue. It has upheld the Union government's August 5th, 2019 order passed by the Parliament. In doing so, it has bifurcated into Jammu and Kashmir and Ladakh. Supreme Court judgment is a historic one in the sense that it clearly states that this is a temporary arrangement made during those years when Jammu and Kashmir got annexed with India, and some part has gone to Pakistan. Pakistan occupied Kashmir and Gilgit regions, both regions, and whereas Jammu, Kashmir, and Ladakh remained with India. So to run the day-to-day administration, they made some temporary arrangements so that it can catch up with India's rule vis-a-vis whether it is welfare, development, or day-to-day governance. So for that purpose, Article 370 had been brought in to give that special status. How it was used or misused, misutilized, now everyone knows. How Pandits were driven away, we were showing show after show. What was BJP doing sleeping? A movie was also made since 2019, why Aborigine Pandits could not settle in Kashmir. When someone tried, they were killed mercilessly. Is it not the failure of government? That is why what the law and order issue. And before this abrogation, how militancy, the religious fundamentalist militancy, you have to keep this in the mind. In the in a peculiar or special circumstances, this Jammu and Kashmir and Ladakh region was annexed. That time was a Hindu ruler, Hindu Raja, and subsequently what happened? How the political parties dominated by Kashmiri Muslims. And what happened to Pandits, the Aborigines? They are also Aborigines. And did Kashmir, Jammu, and Ladakh regions develop on par with India? And then Article 35 is also there. Only those born in those states can marry. No one can marry, no one can buy the territory there. That means Uniform Civil Code, which we are still trying. That is the main purpose of DRTSPR channel. When you have a common criminal code, how is that? The civil code means marriages and inherited properties and so and so. How is that? That is different with each religion. Only one, Muslim and Hindu. All the others are represented in the court in the form of Hindu only by the courts. If I am wrong, they can correct me. Whether it is Christian, Hindu, all you are represented as Hindu, and only Muslim personal law board. There also we are trying. There should be uniformity in civil as well as criminal courts. Similarly, the development from Jammu and Kashmir to Kanyakumari should be one and the same. Equal benefits. All benefits should go to each and every citizen of this wonderful country. Now, with this Supreme Court judgment, we say Jammu and Kashmir is India. India now can say Jammu and Kashmir because this is the beauty of this great country, this constitution which we have given. We have that freedom of speech, that liberty with which they have filed cases against the central promulgated order in the form of the presidential thing on August 5th, 2019. It has been challenged. It has been challenged. And then immediately after that, Supreme Court took it up, and it took so many years, and it has given time for everyone, like Ayodhya issue. That is the beauty of this great country. We may differ at times. We may debate, discuss, and differ. That is the beauty of democracy. It has allowed this petition, and I only hope it has gone tooth and nail into all aspects of the petitioners too. they say it is illegal. They need to continue with special provisions of Article 370 as well as Article 35A. But Supreme Court, after hearing every party concerned, has come out unanimously. Believe me, it is a unanimous decision of the Supreme Court of India. And judicial review on the decisions arrived at by the Parliament and the presidential orders. Judicial review can happen, and the underlying message to all, right from president to the Sarpanch, Supreme Court has made it very clear that Supreme Court has in it the constitutional vested powers for judicial review of even the President of India's orders if the petitioner can prove that they were of malified or erroneous, malified intentions or erroneous, other than the constitutional viability. So Supreme Court in itself, while upholding the presidential order on Jammu and Kashmir, Article 370 abrogation, it also strengthened its judicial review process, stating it can always review even the presidential orders if they are erroneous and if it is not meeting the criteria of the constitutional, and if the petitioner can prove that. So this is a welcome step in a democracy. We welcome it. We honestly welcome it. हम ये लोकतंत्र में इसकी स्वागत करते हैं कि उच्चतम न्यायालय ये भी कहती है कि हमारे जो भी न्याय का जो भी संबंध है उसमें हमारे माननीय देश के प्रेसिडेंट अध्यक्ष जो भी अगर इस तरह की ऑर्डर्स लेते हैं, अगर उसमें कानूनी के तौर पर या लोकतंत्र की मिसाल पे हमारी कॉन्स्टिट्यूशन जो कहते हैं हम, अगर इसके खिलाफ है वो और कोई पिटिशनर उसके खिलाफ अप्रूव कर सकता है तो उसके ऊपर भी न्याय विचार और फैसला सुना सकती है सुप्रीम कोर्ट। ये एक बड़ी जीत है लोकतंत्र में। और उसके साथ में ये भी आर्टिकल 370 का प्रोरोगेशन भी वो क्लियरली सुप्रीम कोर्ट ने एक यूनानिमस डिसीजन, एक ऐतिहासिक फैसला है और उस देश के बारे में। और आज जम्मू एंड कश्मीर जो है लद्दाख के साथ भारत है। भारत माने जम्मू एंड कश्मीर और लद्दाख भी है। और जो ऐसे परिस्थिति थी जब जम्मू एंड कश्मीर लद्दाख हमारे साथ जुड़ गया था भारत के साथ, उसके तहत ही ये आर्टिकल धारा 370 बनाया गया था और 35A भी है, जहां पर एक सहूलत की गई थी ताकि रोज जो राजनीति की दौर से जो चलता है वहां पर सरकार लोगों के लिए जो संक्षेम हो या डेवलपमेंट की जो हम बात करते हैं, तो उसके लिए रोज के रोज सरकार चलाने के लिए ये धारा 370 लागू किया गया था ताकि वो बाकी भारत के साथ जुड़ जाए, डेवलपमेंट या वेलफेयर के संक्षेम हो या प्रगति के मार्ग पे जम्मू एंड कश्मीर लद्दाख भी भारत के पीछे ना रह जाए। तो इसके लिए वो धारा 370 की लागू हुई थी, इतने साल चली। और देखिए हम पंडित किस तरह पीड़ित, ये अब्रोगेशन के बाद में भी 2019 में कितने पंडित मारे गए और सरकार क्या कर रही है, हम सरकार को पूछताछ कर रहे थे। एक सिनेमा भी बनी है उसके ऊपर कश्मीर फाइल्स की, फिर भी वो पीड़ित पंडित वहां पर क्यों नहीं रह सके। इसके जिम्मेदार सरकार को लेना पड़ता क्योंकि वहां केंद्र की सरकार ही थी। और इसके पहले वे पुलवामा के घटना से सब कुछ, पुलवामा का रिपोर्ट आज तक बाहर नहीं आई। इसके पहले जो गवर्नर थे उन्होंने किस तरह खुलासा किया, उसके बदौलत लोगों के दिमागों में अफवाह फैल गया था। देयर वाज a confusion in the minds of the people after that Pulwama incident, and the erstwhile governor revealed so many things. Let us keep them apart. Now I'll just try to play some videos to make you to understand what was Article 370. Now only I can say Jammu and Kashmir, Ladakh, now they are India. That is wonderful. Now let me hear in the Chief Justice of India, Mr. Justice Chandrachud's words. What was Article 370?
Article 370 is a temporary provision on a reading of the historical context in which it was included. Article 370 was introduced to serve two purposes. First, the transitional purpose to provide for an interim arrangement until the Constituent Assembly of the state was formed and could take a decision on the legislative competence of the Union on matters other than the ones stipulated in the instrument of accession and ratify the Constitution. And second, a temporary purpose, an interim arrangement in view of the special circumstances because of the war conditions in the state. C. We have held that a textual reading of Article 370 also indicates that it is a temporary provision. For this purpose, we have referred to the placement of the provision in Part 21 of the Constitution, which deals with temporary and transitional provisions, the marginal note to the provision, which states temporary provisions in respect to the state of Jammu and Kashmir, and a reading of Articles 370 and 1, by which the state became an integral part of India upon the adoption of the Constitution. We have held that Article 370 is a temporary provision on a reading of the historical context in which it was included. Article 370 was introduced to serve two purposes. First, the transitional purpose to provide for an interim arrangement until the Constituent Assembly of the state was formed and could take a decision on the legislative competence of the Union on matters other than the ones stipulated in the instrument of accession and ratify the Constitution. And second, a temporary purpose, an interim arrangement in view of the special circumstances because of the war conditions in the state. C. We have held that a textual reading of Article 370 also indicates that it is a temporary provision. For this purpose, we have referred to the placement of the provision in Part 21 of the Constitution, which deals with temporary and transitional provisions, the marginal note to the provision, which states temporary provisions in respect to the state of Jammu and Kashmir, and a reading of Articles 370 and 1, by which the state became an integral part of India upon the adoption of the Constitution.
तो ये थी प्रत्येक परिस्थिति में ये धारा 370 लागू किया गया और उसकी जरूरत अब नहीं है और हम कहते हैं कि हमारे संविधान की जीत है क्योंकि यहाँ पर यह भी कहा गया कि अध्यक्ष का भी जो भी निर्णय है अगर वो संविधान या कानूनी तौर पर अगर प्रजा हित में लोकतंत्र के हित में नहीं होता तो उच्चतम न्यायालय का हक बनता है कि उसके ऊपर भी न्याय विचार करे। एक बड़ी जीत है, इसीलिए मैं ये भी दोहरा रहा हूं।
It works even for those who don't believe in it. That is why the Constitution matters, because it works even for those who don't believe in it. That is why the Constitution matters, because it works even for those who don't believe in it.
इतनी बड़ी बात कही, संविधान अगर आपके इसके ऊपर आपको भरोसा हो या ना हो, लेकिन कहते ही भारत के हित में, लोकतंत्र हित में हमारी ये बड़ी संविधान काम करेगा और उससे काम हमारी चलेगा। एक बड़ी जीत है आज। और मैं आपको एक केस का भी मैं बताने की कोशिश करता हूं। ओरिजिनल केस क्या है ताकि आप सभी लोगों को समझ में आए। ये है, देखिए, द सुप्रीम कोर्ट ऑफ इंडिया ओरिजिनल रिट अपीलेट ज्यूरिसडिक्शन, ये पिटीशन देखिए 1099 ऑफ 2019, आर्टिकल 370 ऑफ द कॉन्स्टिट्यूशन विथ रिट पिटीशन। ये सबको इकट्ठा किया गया 2015, 14, 2017, 19 और फिर 19 में काफी डिफरेंट पिटिशंस, काफी डिफरेंट लोग, इसीलिए एक लंबा 4 साल का सफर और सभी को उनकी भाव स्वेच्छ, उन क्या सोचते हैं उसके, ये सब कुछ उनको मौका दिया गया। एक लंबी संविधान की बेंच देखिए। सब मैं केस की पूरी बता रहा हूं आपके स्क्रीन पे। सब बैकग्राउंड क्या है, टेबल ऑफ कंटेंट, सभी बता रहा हूं मैं आपको। ये पिटीशन है, ओरिजिनल पिटीशन The state of Jammu and Kashmir did not possess sovereignty. This is सब कुछ. The constitutional validity of the proclaims issued under Article 356 of the Constitution of India and Section 92 of Constitution of Jammu and Kashmir. Limitations on the exercise of power by President or Parliament under Article. सब कुछ इसके ऊपर चर्चा हुई. They have discussed on a large extent on all these issues for 4 years. Equal opportunity was provided to, I think, every petitioner who had filed this petition, such a gigantic petition. A constitutional bench unanimously upholds the abrogation of Article 370. देखिए, and I'm just trying to run through the petition. It is there in the public domain now. You can sit. राज्यसभा भी ये 2019 में ही इसको पारित किया था आफ्टर लोकसभा के बाद में. Both houses of parliament, Lok Sabha and Rajya Sabha, passed this bill, and the president, Raja Mudra हम जो कहते हैं, he had given consent to the bill, and after which they have approached the court. Like Ayodhya issue, court has provided them lot of opportunities to discuss, to go for the trial, and after which a unanimous decision on this day, the 11th of December 2023. On a case filed in 2019, and they have pulled in all the other prior cases also in regarding Jammu and Kashmir, 2015, 17, 18, and 19. And this is an historic judgment. I'm just trying to run through, as usually, DRTSPR channels does all the evidences it puts on its screen for the viewers to understand. And that is how these channels run, purely based on rule of law, constitution, invoking evidential act. So here is the evidence, and the great constitution of India upholding abrogation of Article 370. सब कुछ है इसमें. 46 pages judgment. Just trying to run through so that you can always go through this. And I'll try to read the last part of the judgment, summarize it for you. The Reorganization Act did not represent the people of Jammu and Kashmir because any alteration to the existing units, their territories, boundaries and names should come not from the center but from the people familiar with the unit concerned. The people affected by the alteration should desire such an alteration. The center which is not aware of local conditions, सब कुछ बताया गया है. They have considered every aspect, the basic aspirations of Jammu and Kashmir. Jammu and Kashmir, Ladakh, लोगों की प्रक्रिया, उनकी सोच क्या है, सब कुछ इसमें सम्मिलित करके इतनी बड़ी जजमेंट ने दिया है संविधान के तौर पर. संविधान की बेंच थी ये. It was a constitutional bench which pronounced this judgment unanimously. So we say it's a victory of constitution. In doing so, Supreme Court clearly stated any order by president can go for judicial review per se, some conditions. Erroneous or with any malefic intentions. That is a big victory. So now people can look up to Supreme Court. Democracy can survive. Just trying to, I'm sorry, it is 476 pages. I said it is 46. Sorry, you have to excuse me. I'm just rushing, sifting through the pages, because this is such a landmark judgment. Believe me, the judgment is 476 pages. Constitutional bench judgment with absolute unanimity. So from here onward, Jammu and Kashmir, Ladakh is India, without any doubt. We had no doubt, but we always believed in the great constitution wherein people have a right to approach the courts on any policy matters. So it took 4 years for the Supreme Court, allowing all the petitioners an opportunity so that run through here. This will be much faster. After which, like Ayodhya, this judgment has been pronounced. 476 pages judgment. We come to the last. I think these are the last operating part of the judgment. We'll just go through. Yeah. The judgment of Honorable Chandrachud, the Chief, is scholarly and it elaborately annotates the complex legal issues. The judgment authored by Honorable Justice Sanjay Kishan Kaul pragmatically demystifies the factual and legal position. Both judgments are in seriatim and uniformly agree that Article 370 of the Constitution of India was a feature of asymmetric federalism and not sovereignty. Article 370 was enacted as a transitional provision and did not have permanent character. The abrogation of Article 370 does not negate the federal structure, as the citizens living in Jammu and Kashmir do and will enjoy same status and rights as given to citizens residing in other parts of the country. Paragraph 2 of CO 272, by which Article 370 was amended by taking recourse to Article 367, is ultra-virus and bad in law, albeit can be sustained in view of the corresponding power under Article 371D. Most importantly, Article 370 has been made inoperative in terms of Clause 3 to Article 370. Lastly, CO 370 is valid. I find it difficult to state that I agree with the reasoning in one and not the other. I therefore respectfully concur with the two judgments. However, I would add with particularization. Dr. Justice D.Y. Chandrachud has elaborately examined and interpreted the power of the President of India under Article 356 of the Constitution of India and disseminated the opinions of Mr. Justice B.P. Jeevan Reddy and Mr. Justice P.B. Sawant in S.R. Bommai and others versus Union of India and the others. Reference can also be made to Rameshwar Prasad and others versus Union of India and another. I also agree with the observations recorded by Dr. Justice D.Y. Chandrachud taking record of the statement on behalf of the Union of India for restoration of statehood of the Union Territory of the Jammu and Kashmir while upholding the creation of Union Territory of Ladakh. This is also very much important. I also agree with the observations recorded by Dr. Justice D.Y. Chandrachud taking record of the statement on behalf of the Union of India for restoration of the statehood of the Union Territory of Jammu and Kashmir. The Union Territory, from Union Territory, the statehood of Jammu and Kashmir has been restored while upholding the creation of the Union Territory of Ladakh. Union territories are normally geographically small territories or may be created for aberrant reasons or causes. Conversion of a state into Union Territory has grave consequences. Amongst others, it denies the citizens of the state an elected state government and impinges on federalism. So it is very clear between state and the center, and it is clearly defining Union Territory. It will infringe the basic rights of the citizens. So it is not good converting a huge state into Union Territory. Conversion, creation of a Union Territory from a state has to be justified by giving very strong and cogent grounds. It must be in strict compliance with Article 3 of the Constitution of India. Such a great judgment. It's a level playing field for everyone. Mr. Justice Sanjay Kishan Kaul has explained the effect of Article 373 and why it continued to operate after dissolution of the Constituent Assembly of the state. I respectfully agree with the detailed reasoning given by Mr. Justice Sanjay Kishan Kaul on this aspect. So this is a wonderful judgment. Now it is very clear. The state, it has restored the clear statehood of Jammu and Kashmir too. On behalf of India for restoration of the statehood of the Union Territory of Jammu and Kashmir while upholding the creation of Union Territory of Ladakh. So Jammu and Kashmir can become a state, elections can be held, and it clearly stated by September 30, 2024, there should be a people elected governance in place like other in India. That is why I say, I play this again and again.
That is why the Constitution matters, because it works even for those who don't believe in it.
For those who don't believe in it.
That is why the Constitution matters.
Again, I'll just play. Is a temporary that I've already shown you. And mind you, there were some rumors going on which have been set right by the Lieutenant Governor there very clearly.
ये पूरी तरह से निराधार है। पूरे जम्मू कश्मीर में न ही किसी को हाउस अरेस्ट किया गया है, न ही किसी की गिरफ्तारी की गई, और ये भ्रामक अफवाह फैलाने की कोशिश है। मैं बड़ी जिम्मेदारी से बात कर रहा हूं कि पूरे जम्मू कश्मीर में राजनीतिक कारणों से किसी को न गिरफ्तार किया गया है, न हाउस अरेस्ट किया।
So the Jammu and Kashmir governor has made it very clear, because the rumors are being floated. Don't believe in them. Kindly don't believe in them. We are trying to bring out all the facts, and it's a great victory. And this already I have shown you. A brief of this also interpretation which other channels have been doing.
Also abrogate them achieves what would have been attained by an agreement of merger. With the issuance of the proclamation, paragraph 8 of the instrument of accession ceased to be of legal consequence. The proclamation reflects the full and final surrender of sovereignty by Jammu and Kashmir through its sovereign ruler to India, to her people who are sovereign. Third, neither the constitutional setup nor any other factors indicate that the state of Jammu and Kashmir retained an element of sovereignty. The Constitution of Jammu and Kashmir was only to further define the relationship between the Union of India and the state of Jammu and Kashmir. The relationship was already defined by the instrument of accession, the proclamation by Yuvraj Karan Singh in November 1949, and more importantly, by the Constitution of India. Fourth, there is a clear absence in the Constitution of Jammu and Kashmir of a reference to sovereignty. In contrast, the Constitution of India emphasizes in its preamble that the people of India resolve to constitute themselves or to constitute India into a sovereign, socialist, secular, democratic republic. Fifth, that the state of Jammu and Kashmir became an integral part of the Union of India is evident from Articles 1 and 370 of the Indian Constitution. It is reiterated in Section 3 of the Constitution of Jammu and Kashmir, which is unamendable. Sixth, the preamble of the Constitution of Jammu and Kashmir, Sections 3, 5, and 147 of the State Constitution, coupled with Article 1 of the Constitution of India, read with the first schedule, as well as Article 370, indicate in no uncertain terms that a system of subordination as understood by the definition of sovereignty exists, by which the state is subordinate to the Indian Constitution first and only then to its own constitution. Seventh, all states in the country have legislative and executive power, albeit to differing degrees. The Constitution accommodates concerns specific to a particular state by providing for arrangements which are specific to that state. Articles 371A to 371J are examples of special arrangements for different states. This is a feature of asymmetric federalism, like Article 370, which became applicable to Jammu and Kashmir on the adoption of the Constitution. The state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. And eighth, the limited question before the Constitution bench in its decision in Premnath Kaul was whether the monarch held plenary legislative powers after the Constitution of India as it applied to Jammu and Kashmir was adopted in the state, but before the Constitution of Jammu and Kashmir was adopted. A decision is an authority for the proposition which it decides. The question whether the state of Jammu and Kashmir retains sovereignty upon integration with the dominion of India did not arise in that case. The next issue which we have addressed is the challenge to Constitutional Order 273, CO 273. To answer this issue, we had to decide on two issues. One, whether Article 370 is a temporary provision, and two, the effect of the dissolution of the Constituent Assembly of Jammu and Kashmir on the scope of powers under Clause 3 of Article 370.
So which we have already.
We have held that
Dealt.
Article 370 is a temporary.
Which we have already dealt. So I'll try to play one more video before an opinion from bar and bench before various have expressed various types of opinions, but all in consonance.
We are live, as promised, from the Supreme Court of India to talk about the Article 370 judgment. We'll be waiting for a bit for the viewers to join in. Do send in your comments about the sound, about the autistics involved in the entire process, acoustics involved in the entire process, because obviously, you know, we are from the Supreme Court. There are too many people here, too many sound bites going on. We'll be waiting for a bit before starting on the live, because, you know, there's a lot of reports going around about the abrogation of Article 370. What has the Supreme Court held? What is the verdict in a nutshell? Of course, our story from the Supreme Court is also up and running on our official website. However, here I am, Debayan Roy, breaking down the judgment in a bit. If you could just give me about 30 seconds to begin the entire video for everyone to join in and understand this entire historic judgment by the Supreme Court of India today. So just giving a backdrop, about 16 days of marathon hearing went on, after which the 5-judge constitution bench of 5 senior-most judges of the Supreme Court of India reserved judgment in the batch of petitions challenging the abrogation of Article 370. Now, there were 3 major judgments today. However, all of them were on the same plane and they concurred with each other. Chief Justice of India D.Y. Chandrachud penned one judgment for brother Justices Suryakant and B.R. Gavai, and Justice Sanjeev Khanna had authored a separate concurring judgment, followed by Justice Sanjay Kishan Kaul has also authored a separate concurring judgment. The interesting part is, like the Ayodhya judgment, in this judgment also you would find an epilogue. But you know what is different than the Ayodhya judgment and this judgment is that the epilogue in the Ayodhya judgment was anonymous. But in this judgment, the epilogue has been authored by Justice Sanjay Kishan Kaul, where he talks about and speaks about, from a sentimental point of view, about the exodus of the Kashmiri Hindus from the valley in the 1980s and how it took toll on the entire political climate of India. Okay, so I think we have enough people for us to begin the live now. So the majority judgment is by all of the judges, but the first judgment was read by Chief Justice of India D.Y. Chandrachud. Let's just understand a bit before we start that senior advocates like Kapil Sibal, Gopal Subramaniam, etc. had put their point across from the perspectives of the petitioners in this case, which were a large number of petitioners, whereas Attorney General R. Venkatraman, Solicitor General of India Tushar Mehta, and others had put their point of view forward for the Government of India. Now, I'll just cut to the chase and tell you one thing very clearly, that the Supreme Court has indeed upheld the abrogation of Article 370 of the Indian Constitution. But how has it been done? What is the way that has been adopted, and which way has been upheld by the Constitution by the Supreme Court is something that we are discussing today. Now, there were 2 constitutional orders which were passed: Constitutional Order 272 and Constitutional Order 273. Now, the issue is the Constitutional Order 272 had amended Article 367 of the Indian Constitution, which is a general article in the Indian Constitution which speaks about how to interpret various articles of the Indian Constitution, and thereby a clause or a wording in Article 370 termed as Constituent Assembly was replaced by Legislative Assembly. Okay, so this was Constitutional Order 273, which interestingly formed the basis of Constitutional Order 273, by which President Ramnath Kovind, as he then was in August 2019, had abrogated Article 370. Now the question is, the Supreme Court today has actually struck down the constitutional order of 272. Thereby, Supreme Court has said that you cannot use the way of a constitutional order issued by the President of India to amend a part of the Indian Constitution. This would be disastrous for the Indian Constitution. If today the Supreme Court would have upheld this entire exercise of amending Article 367, thereby rerouting it to Article 370, substituting the word of Constituent Assembly by Legislative Assembly, then this would have opened, a gateway to future such actions wherein the entire process of getting a majority in the Lok Sabha, Rajya Sabha or constitutional amendments would have to be just surpassed. So that is one of the reasons what weighed down with the 5-judge constitution bench, and they struck down constitutional order of 272. However, the Supreme Court in a nutshell has ruled that the President has all the power to abrogate Article 370, and thereby the Constitutional Order 273 was upheld. So, how हम लोग इसको आम वर्ड में कैसे समझे? आम वर्ड में हम लोग इसको ऐसे समझेंगे that there was no need for any amendment to change the wording of Constituent Assembly to Legislative Assembly. The President could have done it as well under 370 Clause 3, and the President has all the power to do it because the President has been working under this article to extend the provisions of the Indian Constitution to the state of Jammu and Kashmir since the 1950s. So might as well apply the entire Constitution of India to the Valley, and thereby making Article 370 redundant. So these are the two ways, one led to another. 272 led to 273, and 272 has been struck down because it would have been disastrous for the Indian Constitution to have such an surreptitious way to amend the Constitution. However, 273, which actually led to the abrogation by President Ramnath Kovind, was upheld. Abhi Hindi mein bol, my Hindi is not that strong. We have other Hindi reporters who would actually take you through that bit. Now we would get to certain questions, but first let me break down the judgment for you in bits. The Supreme Court today has basically ruled down that the state of Jammu and Kashmir does not have any element of internal sovereignty. One of the key contentions put forth by senior advocates Gopal Subramaniam and Kapil Sibal was that Jammu and Kashmir, ever since ever the instrument of accession was signed in by Raja Hari Singh, then thereby his grandson, etc., the particular state of Jammu and Kashmir had an element of sovereignty involved, and that is why the self-rule aspect, some of the constitution of Jammu and Kashmir retained certain provisions by which the state assembly could enact or could legislate on certain aspects, whereas on areas of foreign relations, security, etc., Indian constitution had an upper hand. However, this entire perspective of having this internal sovereignty was struck down by the Indian constitution today, and it felt that the Jammu and Kashmir actually did not have any element of internal sovereignty from the very beginning. Then came the challenge to the proclamation of the presidential order or the presidential rule, which was again held to be invalid. Then exercise of power of the president must have a reasonable nexus. So in this point, the Supreme Court has basically ruled that when the president is exercising his powers after proclaiming presidential rule, then that particular power has to have a nexus, with the object it seeks to achieve. When we study Article 14 of the Indian Constitution as law students, and many of you lawyers are actually logged in, there is a concept of intelligible differentia. Intelligible differentia basically means that a law is held to be valid if the law achieves the object for which it creates a kind of classification, right? So in this aspect also, the court has applied a similar logic to it, that the presidential power would be valid if it is in a reasonable nexus to the object which the proclamation of the presidential order sought to achieve. And what was that object? Object was to have a complete integration of the state of Jammu and Kashmir with India without any shackles of internal sovereignty, etc., and to apply the entire Indian constitution to the state of Jammu and Kashmir. So that is the basic crux of what this reasonable nexus means for my non-legal friends here. Then I have to look to my notes also in between so that I don't give you any incorrect information. One of the major points that was argued by the senior lawyers in the court, which is also one of the most important points, was Article 370 is not a temporary provision. After the Constituent Assembly, which dissolved in 1957, Article 370 became a permanent provision of the Indian Constitution. However, Supreme Court has completely ousted this argument today, and Supreme Court has ruled that Article 370 was indeed a temporary provision to serve the purpose of a transitory time. When India gained independence, Jammu and Kashmir signed the instrument of accession. There was wartime, there was complete warlike situations in the state of Jammu and Kashmir at that point of time. So Article 370 had to be there, or Constituent Assembly had to be there for that particular time, and 370 was retained in the books even after Constituent Assembly was dissolved, because the situation that we just spoke about, the wartime situation that happened in Jammu and Kashmir, continued to exist even after the Constituent Assemblies ceased to exist. So now the entire intent of the proclamation of the presidential rule was the same. The intent was that we need to gain certain normalcy in the valley. At least that was the contention of the central government, and that was one thing that has been upheld by the Supreme Court of India. You must remember that when you are logged in to a bar and bench live, it is essential that we don't give any of our illegal or political opinions or views in this live. It's essentially the arguments of the petitioners, arguments of the respondents, and what the Supreme Court ruled. It's up to you actually how you see the judgment, how you break it down. We are not analysts here analyzing the judgment, and this is actually one of the answers to one of my fellow viewers who is asking me for my legal opinion in this. Legal opinions can be given in an opinion article, not a live session, my dear friend. Then we come to the president's use of power which was not mala fide. So basically the Supreme Court has today ruled that the entire intention of or entire exercise of the president to abrogate Article 370 did not have any mala fide. Mala fide is basically a legal term by which we say an evil intention, right? The intention of the president was not mala fide, because the president essentially wanted the national integration of Jammu and Kashmir into India, and the Supreme Court of India actually uses the word that Article 370 Clause 3 is for a national integration of Jammu and Kashmir, and it cannot be used for the purposes of national disintegration. So this particular line explains the judgment that what Supreme Court has held, that if Article 370 Clause 3 as suggested by the petitioners cannot be used after the Constituent Assembly ceased to exist, then the entire article or the Article 370 Clause 3 becomes frozen, and the entire objective of 370 Clause 3 was once to achieve full statehood for the state of Jammu and Kashmir, to integrate Jammu and Kashmir into the Union of India, and that process of integration cannot be disrupted. A full statehood point, I misspelled it, but the entire point of full statehood is that the Solicitor General of India, Tushar Mehta, had submitted before the Supreme Court that full statehood would be restored to Jammu and Kashmir. And the court has today said that it has to be done as soon as possible. I know there will be questions on, there is no time limit given, etc. But that was one of the, points discussed during the hearings as well, where the petitioner said that it would never be done, and the central government would come again and again and say that, you have not given the statehood to us. However, the court has today said that the Jammu and Kashmir Assembly elections have to be held by the end of September 30, 2024, which is a directive which all 5 judges have concurred with. However, the court has also said that the full statehood has to be restored as soon as possible. So this as soon as possible, yes, my dear friends, is a very vague term, and I agree with you that there are chances of certain mala fide playing in this entire aspect of as soon as possible. However, that is again up to the court. If the petitioners want, they can approach the court, putting an application, putting a fresh plea that, this Supreme Court judgment had held that full statehood would be given as soon as possible. However, today has been 7 years and full statehood has not been granted to Jammu and Kashmir. So what is the government of India doing about it, and when will full statehood be given? And perhaps in future point of time, when Justice perhaps P.S. Narasimha is the Chief Justice of India, he would decide this particular question of law. However, that remains open as of now. Now we come to the point of these were the broad points, and the court has actually noted that the president has all the power under 370 Clause 3 to abrogate the Article 370 because it was a temporary provision, and thereby it is now redundant. Court has also ruled that the Constitution of Jammu and Kashmir is actually not superior to the Constitution of India, and Constitution of Jammu and Kashmir has become inoperative and redundant as of now, and the Constitution of India is something that is completely applicable to the Jammu and Kashmir as of now. The Supreme Court has also upheld the demarcation of Ladakh into a separate union territory, and Ladakh would remain to be a union territory in the books after the Jammu and Kashmir Reorganization Act of 2019. The Supreme Court has also held that the Jammu and Kashmir Reorganization Act 2019, whether it is valid or invalid, cannot be got into now in this present proceedings, and the validity has to be assumed to give certain directions in this particular case. In this case, the court has actually upheld the abrogation of Article 370 through the route of the presidential use of power. power, and not through the use or not through the way of amending Article 367, by which the word Constituent Assembly was replaced with Legislative Assembly in Article 370. The court has actually said that way of amending the Constitution is legally wrong and legally impermissible and would be disastrous for the Indian Constitution, and that is why the court has upheld the exercise of abrogation of Article 370 through the route of the presidential power. Okay, so this was, the entire judgment, and now please bear with me before I take your questions. Okay, so unfortunate that the Constitution used to suppress or destroy a separate Constitution. How come CJI's judgment ended up on this decision? Well, okay, this is not for me to answer, but yeah, you can maybe drop an email to the CJI. A set of laws for internal functioning of a state. A set of laws for the internal functioning of a state cannot be said to be the Constitution. Yeah, so that's what the Supreme Court actually rules about today, that there is no restriction on the powers of the Parliament to legislate on non-legislative subjects of the state. This basically means that the entire exercise of the Parliament to act in absence of the Legislative Assembly was correct. I'll just try to explain this bit because it may sound a bit confusing to our viewers. When you replace the word Constituent Assembly with Legislative Assembly, you have a goal. The goal is Constituent Assembly is non-existent, right? But Legislative Assembly is existing. So when you replace that word, that basically means that you're saying that, when Legislative Assembly is not in session, because Legislative Assembly was not in session because there was President's rule. So when there was no Legislative Assembly in session, there is no need for a concurrence with the state government, and that is why the presidential power or the presidential proclamation of the notification comes into the picture. So this was the entire idea. This was the entire idea behind that amendment. And how Supreme Court has seen is that Supreme Court has said, even if you did not amend Constituent Assembly with Legislative Assembly, even if you did not go through this, under backdoor entry of amending 367, etc., even then the President had the power to abrogate Article 370 because it was a temporary provision and it had to go one day. Okay.
So this is very clear now. It's a temporary provision. The President of India, that amendment is very clear through Article 267, is not in consonance with Constitution. They said directly you have power to abrogate, and that is what the Supreme Court unanimously upheld by not allowing backdoor method. So these were the wonderful judges who had passed this order. So thanks to bar and bench, credits to that. It is there in the public in Instagram. You can always go through and solicit the videos. Just trying to show you, we give credit wherever it is due. And it is a historic decision. No, trying to just run through this. Various decisions made by central government on behalf of the state cannot be questioned, allowing such, and it has dealt with the federalism aspect. So it is restoring the statehood of Jammu and Kashmir while agreeing to Ladakh as union territory. And then it asked President, you have power. When you have power to abrogate, why should again you go backdoor method to amend Constituent Assembly into Legislative Assembly by amending those articles, which they were very clear. So before I say bye, it's a great day. Again, let me play this.
Because it works even for those who don't believe in it. That is why the Constitution matters, because it works even for those who don't believe in it. That is why the Constitution matters, because it works even for those who don't believe in it.
So I'm stopping it here. This is from DRTSPR channels today. No confusions. संविधान जो है, संविधान के मतलब जो है हम हैं, नागरिक जो है, भारत के नागरिक जो है संविधान है, खुद संविधान को हम अपने आप को अर्पित किया है. Constitution means we, the people. We have submitted this constitution to ourselves. రాజ్యాంగం అంటే మనము ఈ రాజ్యాంగాన్ని మనకు సమర్పించుకున్నాం కాబట్టి ఇది గొప్ప దినం. It is nothing but the Constitution wins, India wins, democracy wins, every citizen of India wins. That is why we say Jammu and Kashmir. When I say Jammu and Kashmir, Ladakh is a part of it, is India now. No more questions. In unanimity, they have upheld the abrogation of Article 370. Do support DRTSPR channels, Citizen DRTSPR channel, and Environment People DRTSPR channels. They are all in larger public interest. You know how YouTube and Google have been playing havoc with DRTSPR channels without any notice. They remove. And why the union government, in spite of the complaints, is keeping quiet during the elections in 5 states, Election Commission of India, we have complained why it is also keeping quiet. It is still a mystery, and Supreme Court of India, I think it should take its own motto, because I always make Supreme Court of India, High Court of India, and all the other legal organizations part of my complaint all the while. So if you have any doubts or if you are opposing, you are most welcome. I will host you again. My mobile number is 94404-65339. For WhatsApp purposes, anyone can complain to me. And even this is the Google Pay and Phone Pay number. Anyone, if you want to contribute, you can contribute. And do share, subscribe, and support DRTSPR channels. They are all in larger public interest only.